I don't think so.
There we go. Okay, we're starting, and we'll start in 1 minute and 60 seconds.
Okay.
So, yeah, but the other thing is, we all send our lawyers. I know I see you quite a bit at different conferences, and we send lawyers to conferences, again, sharing that knowledge with everybody.
Right.
So it's not stuck in one person, that type of thing. The experience that you and I get when we go to these conferences is valuable.
Mm-hmm. No, 100%. Shoot, I'm seeing lawyers from my firm that I've not seen in ages, like old Zach.
That's right. I
I
went to
didn't know
lunch
Zach
with him.
existed. I only know him through email.
Well, hopefully by Zoom. Hopefully you see their faces.
Sometime.
Everybody, if you're not muted, please mute yourself. I can probably mute everybody, but if you're not muted, please mute yourself. What we're going to do is have a presentation for hopefully about 45 minutes, and then we're going to open it up for questions and comments. And so everybody will have an opportunity then to, we'll open up the screen and, make comments or questions or what have you. So I'm going to start now. I want to thank my friend Jerry Hamilton, who's a founding partner at Hamilton Miller, Southeast United States insurance defense firm with multiple offices. Jerry and I, we've known each other for many, many years. Jerry's a fantastic lawyer, a two-time chop for chop champion. So I've seen him in action, very, very sharp. And we were just comparing notes, very similar law firms. Kopka, Pincus, Dolan is about 100 lawyers, insurance defense of a wide variety of types of practice, very large casualty cases, a trial firm, something that most firms aspire to, call themselves litigators, but they don't try cases. Jerry's firm tries cases, our firm tries cases. We're on trial now, right today in some of our jurisdictions, and we're on trial every month somewhere. And so Jerry and I see each other quite often, and I was telling Jerry about our program. We share our knowledge and we share our talent at our firm, and happy to share our knowledge and of how we do this with Jerry, who's thinking about instituting it at Miller, at Hamilton Miller. What we do is we meet together and we talk about trial techniques. We teach trial techniques every recording. As I say, if you're not muted, please mute yourself. So I want to thank you, Jerry, for joining us. I'm very excited about this program. We decided to choose a topic that I think is near and dear to us on large cases, which is anchoring. And the first thing I want to do is get everybody aligned in terms of what we're talking about. Doing a little research, here's what I wrote. Here's what I found. Anchoring is a strategy used to cause jurors to rely on specific reference point or anchor when evaluating damages in a lawsuit. It's a sociological and psychological phenomenon, the anchoring effect. And the idea here is that when you hear something, the first number that you hear anchors your thoughts in terms of what you're seeing. And we've seen it in voir dire, we've seen it in opening statements, where the plaintiff is asking for a sky-high number and expecting to get less, but that number then anchors the juror's mind, and they deviate from that number as opposed to coming up with their own number. And Jerry, maybe you can just comment on that as a phenomenon.
And Bob, before I comment on it, I really want to thank you for setting this up. And I think I look to your firm always for guidance and leadership, and because, as you said, we're the same practice, but you've done so well with your firm. For instance, this particular program that you have, that you're sharing your knowledge with the firm. It's something that we're going to institute, and just because, Bob, of your leadership and what you're doing and the success of it, I think this is just great. So thank you again for setting it all up, Bob. And listen, talking about anchoring, I think it is one of the there are few reasons why we see this trend of nuclear verdicts going up, and runaway verdicts going up. And I think anchoring is just one of the ways that is causing verdicts to increase and verdicts to really just be disproportionate in terms of what we see in trials. And so, with respect to anchoring, Bob, I think you gave it, we were talking just before this, and you gave a great example in terms of this, the concept and the study that you'd read regarding the folks who came into the auditorium and saw the number. And I think that would be a very good example, just to give folks a nice visual of what anchoring is, but it truly is where the plaintiffs come in with a number and they start with that number and they say it early, they say it often, and it just sits in the mind of the jurors. It starts in jury selection, it goes through opening, it goes through the direct and the cross examinations of all their witnesses and our witnesses, and it ends in closing. And the jury just has that number, that first initial impression in their head, and somehow think that that number validates what it is that they're going to do on a verdict form. So, but I think if you tell that story, Bob.
Well, yeah, the story is it's actually from the 1970s. It was a study. It was really the initial study that kind of used the word anchoring as a concept, which is they call it a conceptual bias. So they're creating a conceptual bias. They're giving you a bias to begin with, and it's so subtle that you don't even know it. So the study was, they brought a group of people into an auditorium, and on the screen in the auditorium was the number 13. This was in the 1970s. African countries were beginning to join the United Nations. So to ask a group of Americans, how many African countries are there in the United Nations, is a question nobody's likely to really know the answer to. The first group they brought into the auditorium, on the screen in front of them was the number 13. And then they put the question, write down, please, how many African countries do you believe are members of the United Nations? The control group in the next auditorium had the number 65 on the screen before they were ever, those numbers weren't even explained to anybody. They were just on the screen. Then the next screen comes up, how many African countries do you believe that there might be in the United Nations? And over and over and over again, they found that group with the anchor, that number 13 in the beginning, uniformly had a much lower guess than the group that saw the number 65 at the beginning. They uniformly had a larger number. And it illustrates what they're calling a conceptual bias, the idea that we're going to plant something into your head. You don't even know it's there. It's a tactic. And that will affect the outcome of your decision-making on something that isn't precise. They're not asking you to add 2 plus 2, nor are we asking jurors to add 2 plus 2. These are ephemeral numbers that they have to come up with. And so anchoring in their mind a number, like you said, in voir dire, it has a psychological effect. And I want to talk a little bit today, we'll get to it. What can the defense do about it? After all, plaintiff goes first. Right? So you're afraid that anchor is the anchor. But that's the psychology of it. And by the way, I want to mention one other thing, as long as we're talking about the psychology of it. You talk about reptile theory a moment ago, and in a sense, it's very much related to that, because it's, let's say, an innate characteristic of the human condition, if you think about it. I wrote on the outline here, sum things up quickly. All of us.
Recording in progress.
Excuse me, all of us. As we, let's say, walk into a dark alley and you see a shadow, you make assumptions. Or you're walking down the street, you make assumptions. Whatever we're doing, we're making assumptions based upon our experience as we are experiencing life. And it's that quick decision-making that's kind of innate in the species, you might say, that is the antecedent of this idea of conceptual bias, that we're going to tell you something, you're going to believe it right away, you're going to see it right away, you're going to anchor your thoughts about it right away. And so, it's very much like the reptile theory in the sense that it's appealing to kind of a human condition and using the psychological tactic for one side or another's advantage.
Mm-hmm. Yeah, no question about it. And Bob, let me just piggyback on that. And I know you're going to get to this, but as defense lawyers, our traditional approach has always been to really fight on liability, or fight on causation. But we really don't focus on the number, and we don't really focus on the damages. Whereas the plaintiffs, really, of course, it's all about the money, right? They equate money and justice. When you hear the word money, they say that's justice. And so they talk about the money, and they're talking about it constantly. And so, if they're doing that, and you talk about your cognitive bias, right? Then you got to question then, if the studies are true, and I've read some of these studies, and I've looked at some of the studies, that the plaintiffs are just anchoring, right? And the defense is doing otherwise, which is disregarding the number. To the extent that the jury disagrees with us on liability and causation, that anchor is going to stick. And that's what you're seeing, is that a traditional approach that we're taking as lawyers in trying these particular cases just isn't working, and we need to make a shift on how we try and present cases. And it's not even just in trial, because this process, as Bob and I will talk about, starts in discovery and starts with interrogatories and starts with deposition. So, Bob, I'll let you move on to the next point, but I just wanted to say that the reason why Bob and I are here talking about this is because there really needs to be a shift in the mindset of how the defense deals with damages. We know all about liability, and life care planners and economists. We're so good at that as defense lawyers, but we just don't know how to necessarily argue, say, non-monetary damages and to get to lower verdicts.
Yes. So let's start with the plaintiff strategy. Let's start with the opponent, and then we'll talk about the strategy to attack that strategy, if you will. So unfortunately, as we all know, the plaintiff goes first. And so I was, attending one of my partner's trials last year, and the very good plaintiff lawyer, known to be a very significant, to have obtained significant damages on a case that really didn't warrant those kinds of significant damages. First thing out of his mouth in voir dire was, "What would I have to show you in order for me to convince you to award $14 million?" And boy, oh boy, no one flinched. And some of the answers, of course, as you can imagine, are, well, $14 million, that's going to have to be a severe, significant, you get all these responses from the jurors, and I realized it because he kept some of those jurors on. Okay.
Right.
So he's not really looking for specific answers. He's anchoring that number. He's getting the jurors to think about that number. He's talking to different jurors about that number. And he didn't eliminate anybody for their comments on that number. And that was clear to me what he was doing, and obviously also to my partner who was trying the case, it was clear that what he was doing. And that's how they do it. They ask for the moon. And what else have you seen? How have you seen, sticking with the plaintiff's case, before we get to the defendant's case, what have you seen as far as a tactic from the plaintiff's side to use this anchor?
You're right. They start off, Bob, with not only just, throwing out the number in terms of asking, well, as you said, what would it take to award 14 million? But another approach is, when they, I've seen it now multiple times in jury selection, when they actually put up a chart and they say from 0 to 10, right? How many of you think that 20 million, right, is an excessive number? And they're just polling the jury, and they say they're polling the jury. And the reason they're doing that is, of course, they want to come back and say, the judge is going to say there's no limit on the damages. And, to the extent that you have a preconceived limit, you should be off and be struck for cause. But the fact is that by throwing that number out there and kind of getting the jury on a 0 to 110 scale, it's as if the facts and the evidence were to show that the plaintiff was entitled to $20 million. And I want you to assume that the facts and the evidence show, from a 0 to 10, I mean, who thinks that 20 million is just an excessive number? And the jury comes back and, what about you, Mr. Brown? Well, from a scale of 1 to 10, 9 being it's too much, I'm a 9, I'm an 8. And so they're but while they're talking to those jurors about who's a 9 and who's an 8, yes, you're going to get rid of some of those jurors maybe, and they'll dig deeper with some of those particular jurors. But the other jurors are being desensitized to that number. And that's the trick, is to desensitize the jurors to these large numbers. Because if you say it often and you say it a lot, then it just becomes, oh, okay, it's just $20 million. It's not that much money. And so we see that trick again in voir dire, where they have these scales of 0 to 10. We have a very popular plaintiff's lawyer here that likes to use that tactic to try to anchor in jury selection under the guise that, judge, I'm just trying to ferret out any jurors who might have a bias to limiting damages in the case. So we see that a lot.
And
Bob.
mention also, I love the fact that you mentioned that somebody puts it in writing, because at the end of the day, that also, reinforces in their head, seeing it on a chart. Mention
Yeah.
also, all the phenomenon that we're seeing post-COVID, which is a higher degree of distrust for corporations, a desensitization to what a million is and what a billion is, and talk a little bit about the environment. Everyone's talking about it. The environment trying cases to a jury.
Yeah.
As-
Listen, the environment, Bob, and I'm sure you're seeing this, but here in Florida, it is really a tough environment now. I mean, we have, Florida is a very polarized state as it stands right now. And so, yes, we're coming out of the pandemic, and the pandemic was certainly, a tough time for everyone. And jurors are coming out a little bit more angry, not only, at corporations who may have, who they viewed had unreasonable responses to the pandemic, whether it was laying folks off or requiring masks, because just depending on your political bent, that corporation isn't, one with you. But we're seeing all the social inflation issues, and especially with all the athletes who are making all this money. But then we have the largest personal injury law firm here in the state. We have Morgan and Morgan. This is their home base. And just the other day, it was published that they spent about $25 million on just advertising alone in South Florida, right? And so we see the billboards everywhere that talk about, I just got 15 million. Or listen, the insurance companies are, offered 10,000 and we got 800,000. And so the desensitization starts in even before we get to the jury. And so, in certain instances, and this is a question we have to ask in Florida, the mere fact that this is a Morgan and Morgan case, do you think this case somehow has some validity, or somehow they're ahead because there are jurors here that have seen all this advertising and said, hey, if that firm took the case, then it must have some merit and it must have some value. And it
Wow.
must have the value that you're seeing on the billboards, right? Because John Morgan's knocking it out of the park. It's not really him because he's never tried a case, but
Right.
it is that we have to now deal with in jury selection, to even ask if it's a Morgan and Morgan case, or we have another lawyer called Rubenstein or Dan Newland case. We have to drill down and just make sure that these jurors are not conditioned by the fact that this law firm, just by representing this particular client, is somehow now, this jury is now biased because they think that must mean there's money to be had and the case is valid. So it's a tough pool that we have to go through, and the plaintiffs know that, and that's why the plaintiffs are asking those types of questions regarding, what's your view on excessive verdicts, what's your view on frivolous litigation, what's your view, or what do I need to show you to get to a $14 million verdict. Right?
Yeah, there was a time, I mean, remember back when the McDonald's verdict, and people still talk about the spilled coffee, as an excessive verdict. And there's a time when it was the defense attorneys always talking about, have you heard of the McDonald's case? Or what do you think about excessive verdicts? Or what do you think about frivolous lawsuits? The plaintiff's lawyers are asking that question now in voir dire, in order to neutralize that notion.
Mhm.
So that's what the plaintiffs are doing. All right. And so let's talk a little bit about the defense perspective. We go last. They've already heard $14 million several times. They're all talking about $14 million. And you and I talked about the fact that anchoring from the defense perspective is more than just a number. So maybe we can explain that.
Yeah, it definitely is. I mean, it's certainly not only anchoring just to the number, but anchoring to certain actions that the plaintiff can do, right? The fact that you can have the plaintiff who is rehabilitated, the plaintiff talking about their disability, and the fact that people with disabilities can, go on to do great things, that they're just simply not there sitting on the couch, not doing anything. Their life is not over. You can anchor to those types of things, Bob. But, more importantly, I think you do anchor, with respect in voir dire, with respect to money. Also, I think that's important. I think it's important for the jury to understand that if the facts and the evidence show that, the value of this particular case is X amount of dollars, whether it be, and listen, whatever number you put out there, it better be a credible number, better be, in voir dire, it better be a number that necessarily does not fluctuate, right? And so if you say, listen, the evidence shows that it's 100,000, but the person is, horribly injured, can you listen to the facts and evidence and come back with a verdict for that amount, given who this plaintiff is and what this plaintiff has gone through? You've heard the judge is going to instruct you on sympathy, not to factor into your case. We get all of that, but I just want to do a deeper dive as to, can you listen to this evidence and look that plaintiff in the eye? And if I prove my case, if I bring you this evidence, would you be able to do it? But that's anchoring to money. And I think anchoring to money is absolutely important, but anchoring also on issues of, what this plaintiff did in a career and how they, how it is that they'll be able to carry on and move on in jury selection. I mean, just putting those themes into the jury selection is very helpful. I'm interested in your thoughts on that, Tim.
Well, you mentioned two incredibly important things, and they're separate. So taking them, one at a time. The first question is, do we as defense attorneys anchor to a number? And we both talk to a lot of defense lawyers. We know defense lawyers around the country, and way too many of them still, in my opinion, and I'm sure yours as well, avoid anchoring to a number. They're afraid that if they mention a number in voir dire, if they mention a number in opening, certainly if they mention a number or urge a number in closing argument, that they've waived their argument, or they lose their credibility with the jury to seek a complete defense verdict. And you and I both know that that's not accurate. And as a matter of fact, before I answer the second part of the question, which is anchoring as a concept as opposed to anchoring as a number, let's talk about some of the studies that Magna Legal Services had done. You and I we both know that, where anchoring to a number was a significant, had a significant impact on the outcome of the verdict. And then you also told me that you anchor to a number every time and get defense verdicts with it. So let me throw the ball back at you, and then I will respond to the second part of the question, which is anchoring to thoughts and concepts.
Yeah. So, in the past, I think I've tried 3 trials in the past, maybe 10 months or so. And every one of those trials, I have anchored to a number. And I've anchored to a number not only in voir dire, but I've anchored to a number through our defense experts, and I've anchored to a number in closing. And every one of those 3 in the past 10 months have been defense verdicts. And every other trial that I've tried in the past, I'd say 2 years or so, which is another 10 or 11 trials, always anchor. I always anchor because the purpose of that is to give our defense jurors the opportunity to make arguments against plaintiff's jurors on when they start discussing the damages. And what would I say? I'll say, listen, I'll go through the entire liability case, and I say, if you disagree, sometimes I know that some of you folks may disagree with what I'm saying. I know that you might disagree with the fact that I believe the plaintiff shouldn't be awarded anything, and that there's no liability in this case. I go through all the reasons of no liability. But if you disagree with me, and it's okay to disagree with me, but if you do disagree, here's what I think you should award the plaintiff and why. And then that's when I go through the anchor number. And to a T, those cases have come back as defense verdicts. And then to a T, when we mock try these cases and we watch the jurors behind the window, they say, well, the defense lawyer said 5, but I don't think they should even get $5,000 or 10,000 or 100,000 or whatever the case might be. And so, I think, just here, let me share a quick screen really quickly, Bob, in terms of the Magna studies here really quickly. But here we have a Magna study. It should be on the screen here. And essentially what they did was they tried a few cases to plaintiffs and the defense. And you see here, it says no defense anchor, and this is a defense anchor. They tried a case, and in that case, the plaintiff's lawyer asked for $95 million. There was no anchor, and the jury came back with an average of $67 million. They tried the same case, but the facts have changed over a period of time. They mock tried it again, but decided to anchor. In this instance, the plaintiff asked for $130 million. The juries came back. There was an anchor that was given at $19 million. the jurors came back closer to the anchor at 22 million, and 83% decrease in the verdict itself. And so there are multiple, and I won't necessarily go through all of them, but multiple examples of where Magna's, and as you know, the firm uses a lot of Magna to do mock trials. But Magna has been doing this now consistently in terms of trying it with an anchor and trying it without an anchor. And then what we're seeing is just incredible results in terms of here, the plaintiff's request was 60 million, no anchor, jury came back at 27 million. Identical case tried again later on because they mock tried a case twice. There was some additional evidence. They asked for 100 million. That was the plaintiff's request. And then there was a 96% decrease when there was an anchor. And so, that goes on. I mean, they gave multiple examples, and I won't go through all of them.
No, and the thing is, these are good examples of the effectiveness of anchoring and reducing the damages. And your anecdotal information is very good information about the fact that you don't give up the defense, the liability claim for defense. And, when you were talking, you remind me of one other thing. Another friend of ours, Bob Tyson, who also has a big law firm and wrote, the book about nuclear verdicts. He points out that from the defense perspective, almost always we've made an offer. We've made an offer. And so defense verdicts are wonderful, but frankly, any verdict under the offer is a win. Right. And so we shouldn't be that afraid of losing. I mean, our pride makes us want to get that defense verdict. But from a business perspective, from the client's perspective, a verdict under the offer is a win. And that's what we should really be, in a sense, going for.
And Bob, I just wanted to circle back and just ask you again, because you talk about anchoring to things other than a number. I wanted to get your perspective on that too.
Okay. So look, I mean, you made the point, which is that, first of all, a number is just a number. And the jury, from the defense perspective, we always try to focus them on what is their job. Okay, the job is compensation. We have to spend some time talking to the jury about what is the purpose, what is their purpose as a jury, what is the purpose of the civil justice system, what is the purpose of bringing fairness into the courtroom. I mean, we talk about fairness, we talk about justice, we talk about civic duty, we talk about following the law. It's hard. You, I, and all 109 people on this call, we do it every single time we try a case, and it's hard to get through to the jury. So one of the things that I think is an anchor is to focus on the plaintiff, him or herself. If they're young, if they're vibrant, if they have, if you find that through Facebook or through social media or through interrogatories that they have an active lifestyle. If you can find through their job history or even their family history that they have a lot of guts and determination, you can bring that to bear on the case. And so even if they don't have that, part of an anchor might be to talk about rehabilitation, to talk about even the Rehabilitation Institute of Chicago here in Chicago, as we talk about, the amazing things that they're doing. Special Olympics is an example of that type of an anchor. Let's talk about what we can do to bring the plaintiff back as close as possible to, pre-injury status. We can't bring them back to pre-injury status, but let's talk about the cost of a new house, or retrofitting the house. Let's talk about the cost of a retrofitted vehicle, a new one every 5 years for the rest of their life. Let's talk about the cost of psychological training or vocational training and rehabilitation to bring, because this is not a person, this plaintiff, who's going to just sit around and do nothing. So in other words, anchoring the money to a purpose, I guess is what I would say. And if you and I and the people on this call think about it, to buy a brand new retrofitted vehicle for somebody who needs it at $100,000 a clip every 5 years for the rest of their life, that adds up to $1 million for 10, you know what I mean? Or even less, $700,000 till they're 90. Okay, so let's put $700,000 on the board, and let's see what else they need. And even like I was saying earlier, if somebody in their discovery says, look, I have a back injury, I can't get down on my hands and knees with my grandkids anymore, and it just kills me. Well, what would it cost to send them to Disney World once a year, or to rent a house for the family, or to go on a family vacation and take their grandkids on a vacation? Something that they can do. Put it on a piece of paper, multiply it by the number of years that you're going to go, and I guarantee you it's not going to reach more than a couple of $100,000. And so you anchor what is essentially the job, the recovery. And I'm talking about non-economic damages now, right? The pain, the suffering, the disability, the disfigurement, the scarring, or whatever it may be. Anchor it to something else, somebody who lives with a scar, or somebody who prevails over this disability. And it's not as easy. It doesn't have that psychological impact that we talked about, but it allows you to arrive at a number that's a much lower number, and it is anchored to something. So I want to show this clip about what happens when a defense attorney anchors without, it's a low ball. I mean, we're not suggesting that if the plaintiff is looking for $14 million, you come in at $1,400 and just keep pounding on that number. That's not what's going to work. You have to have some basis. So let's take a look at this. I want to make sure we share our sound. Okay. And this comes from one of the Magna Legal Services mock trials. May not be working here. Let's see. There we go.
There you go.
It just seemed like the defense was lowballing everything. Like, oh, they want this, we'll give them $50,000, or maybe $100,000. I'm like, okay, this doesn't, you're willing to claim some damages, but, what you think is reasonable. I just felt that they presented, yeah, you're going through these people's medical and mental health history, but you can't discount the fact of what happened. And the defense just seemed, he goes, yeah, it was a terrible incident, and I mean, I don't know what they did about the two people who died in the accident. These are two people who got injured, but it just seemed that the defense was just trying to lowball everything.
Comment there, Jerry? That wasn't you, by the way.
No. Yeah, I think, that's a perfect example of you've got to anchor with a purpose. You can't just anchor just for anchoring's sake, and just throw a number out. The number has to have some reason, some rationale behind why it is that you're anchoring towards that particular number. And so, for instance, recently, I mean, we just tried, you talk about the McDonald's case, we just tried another McDonald's case. We were the ones that, there was a liability trial that we were not involved in. And there was a liability finding that, McDonald's was liable for their chicken McNugget being too hot. So McDonald's reached out to us to try the damages portion of that case because the plaintiff's lawyers wouldn't take a nickel below $2 million. They asked jurors for $15 million. And we had to find a basis upon which to anchor. And this was just a 4-year-old girl who, again, she was now 8 at the time of the verdict, the time the verdict came down. And, we had to find and look for the reasons, as to what it is that this 8-year-old girl would be able to do over in her entire period of life, living with a scar or trying to get plastic surgery. And so, we looked at mom's income, we anchored, we talked about, what mom and dad were able to provide their child, and then say, look at what this money will do for her. It's not only her college, it's not only, her schooling, it's not only dealing with the medical issues or the psychological issues that she might have with respect to a burn. This is all, when you add all of that up, it was still only about anywhere between $100,000 to $200,000. It wasn't a whole lot of money. And so, you factor in the fact that, we talked about she likes to go to the beach. And if she goes to the beach even one time, a month for the rest of her life to 18, and you give her, $1,000 for that, it's still only somewhere in the neighborhood of about $100,000. And so, jury came back, they came back with $800,000, which was a big win for us because we couldn't settle a case below 2 million. The ask was 15 million. I thought Jennifer Miller did a very good job at anchoring in that particular case and just talking about what it is that money could do for this 8-year-old and what money could do for the family. And so, everybody was happy in that case. And
I think that's the right way to do it. Yeah, you talk, what is the purpose and what is the value of the money to the plaintiff?
Mhm.
Two things I wanted to say. One is there's a lot of little videos out there that really illustrate for people what is a million and what is a billion. And I looked it up earlier today. A million, if in order to take 1 million steps, you're going to go 235 miles. And that brings it down to everyday life, A billion, if you were to count to 1 billion and you count one numeral every second, it takes you 31.5 years to count to 1 billion. So using analogy to get across to the jury what these numbers mean is another way to really kind of bring them down to earth and to understand what 1 million is, and that throwing out a number is just throwing out a number.
Right. And, Bob, I want to emphasize the fact that, we're talking about trials and trial strategies, but nothing at a trial happens without getting the information that we need in depositions or in discovery. So, for the lawyers that are listening in this particular case, it's so important to develop that strategy pre-trial, in deposition. Anchoring is not just about trials. It is about the interrogatories that you serve, the deposition questions that you serve, just for example, and I'm going to be circulating this to our lawyers here, Bob, it just, there are questions one can ask in damages cases about how to reduce the damages in this particular case. And so what I'm showing you here are just some sample deposition questions, which I'm going to circulate to the team that talk about the essential non-monetary damages and how to ask questions about them, right? And listen, in every case, in every deposition, I ask the plaintiff, you file a lawsuit, what are you seeking? How much money? They're not necessarily prepared to answer that particular question. And when they tell me how much money they're asking for, I ask them what is it that they're going to do with this money? How is that money going to replace what it is that they've lost? But questions, and I know these are standard questions. Have you taken any vacations? That's a standard question. But a question about what is your passion? What are your hobbies? What do you like to do? Why am I asking those questions? Because at trial, I want to be able to say how the money is going to replace what it is that they have lost in terms of a hobby or in terms of a profession. Do they have their house? Are they worried about losing the house? I want to talk about how the money would stop that. I want to know what keeps them up at night about this particular accident, right? I want to know how they spend their money for enjoyment. These are questions that are typically not standard deposition questions that you typically ask a plaintiff. But in these cases where there are significant injuries, even the cases that don't have significant injuries, it is very critical to ask these types of questions because they will help us to get the evidence at trial so that we can anchor appropriately and say, here's what the plaintiff said about their life, here's what the plaintiff said about their loss, and here's how this money will then meet their loss so that they can have, a full compensation and have justice in the case.
I like this very much, and do me a favor, circulate it to me too. The idea here is, so often we've asked these questions for a singular purpose of opposing the idea that you've lost all this. Oh, you can still play with your grandkids. Oh, you can still do this. But I love the idea of using it to anchor a number. Okay, so you're going to take them at their word, and then you're going to monetize it. You're going to figure out what is an appropriate substitute, if you will, which is exactly what money damages is supposed to do. In a sense, it's a substitute for that, for those non-economic losses. I want to show another Magna clip. What happens when you don't anchor? Okay, if you don't do what Jerry and I are talking about.
Lost earnings will be. can disagree about whether it should be 1 million, 2 million, but you can kind of quantify it. But how do you quantify this woman's lost life and the effect?
You really
and
can't.
the pain and the loss?
She was an only child, right?
I don't remember that. I
50, I mean,
I think it's a lot of money.
Yeah.
I don't think it's a little bit of money. I don't think it's a token amount. I really, the only thing I can go to measure is what's everything else costing? What did we come up with on all the other numbers? We came up with $18.5 million. And I think that's the starting point for the pain and suffering.
So how much further up should it go? Do you think it should be?
I think it should be that number, because I don't have any other way to arrive at a number. And it's the only, we can't do anything about the pain and the suffering. All we can do is try to put a number on it. That's how this process works. And
It
one
could
of
be
the
even
attorneys.
2 times, that could be 40 million. Could be
Well, we
50
know that in
million.
negotiation,
Really.
people always start high and they work their way down.
We're not
So-
negotiating. We're just trying to figure out
Yeah.
what we think is the right number.
How about if we take a poll, see what people,
I
starting
mean,
point.
people may look at this differently. You know, I'd love to hear what other people say.
I'm caught up
think.
on that
That there should be
coma
0 or
situation.
more.
If that accident happened and she immediately went into a coma, at that point, they read to us that statement that if they're in a coma, you cannot award future pain and that counts from that day. That would be the past, like prior to the date we're judging. So you couldn't award anything. If she's in a coma right when the crash happens, you can't award anything. But if they induce the coma, say like a year later, you could pay for that year pain and suffering. Like as much as I want to give her like $20 million, I'm just going by the
think-
law. They just told us in the
I
other
think-
room.
Pete, I've agreed with everything you've said and really listened to. My figure, I don't know where it came from. I was kind of looking at the, somewhere around what we were giving for wages. You know, I know you can't measure pain. You just can't. I mean, that's why neither attorney even touched it.
Right.
But I was thinking around $1 million.
No, I'm way up there. I'm almost like 30
Oh,
or 40
right.
million.
Yeah,
That's
yeah.
where I'm
You're-
at.
you're-
25,
You guys are past me.
Doesn't it drive you crazy? Here's a juror, was not given an explanation for how to think about pain and suffering. So he started at $18.5 million, the number that would be the compensatory damages for the economic loss.
Right.
And had nothing else to talk about.
Yeah, because the plaintiffs, you know, and for the most part, in all these trials that I've been in, the plaintiff has a formula for pain and suffering. You know, pain and suffering component is the largest part of any jury verdict. It's not the economics. And they come up with a formula and they can say, well, listen, you know, why don't you award $2,000 a day? That's less than what they paid the expert to come in here and testify. You know, $2,000 a day to my client until the end of her life expectancy. Jurors can take that back to the room and say, all right, they gave us a formula. What does the defense do? We're not doing anything. So how do we come up with our own formula? We come up with our own formula based upon those questions that we asked. You know, what are your hobbies? What do you like to do? Right. Well, you know, as Bob said, I like to go to Disney World with my grandchildren, or I like to camp. And so you say, well, this is the cost of what it costs to camp. This is what the cost of what season passes to Disney World was. And this is what the plaintiff said they like to do. And that's the number. That's the number for pain and suffering. That's the number, because justice is here to give fair compensation. It's not to punish, not to penalize, but to give fair compensation for what was lost. Right? And if you're going to give fair compensation for what was lost, then you need to know the value of what was lost. And I'm telling you, here's what the value of what was lost is. And it certainly doesn't come up to 14 or 20 or $50 million, because I'm sorry, those numbers are astronomical numbers, and the plaintiff didn't lose that. And we can certainly all we can do is replace it with the money for things lost. And here's how we compute it. So that when they go back to the jury room, they can say the defense gave us a number, and here's how the defense computed it. Maybe I disagree that Disney World is going to cost $10,000, maybe it's $20,000, but at least they have that anchor number from the defense to talk about what it is that what was lost, rather than say, well, the defense didn't talk about it, the plaintiff didn't talk about it, nobody touched it, so we just need to come up with,
Right.
imaginary numbers.
Right. So this has been very helpful. I want to focus a little bit about we've talked about what the defense needs to do in order to establish a number, to anchor that number to reality, to convince the jury that these numbers make sense in terms of this particular plaintiff. Here's a couple of other things that defendants can do. First of all, one way to attack the plaintiff's anchor is to identify it straight away to the jury. Let me tell you what the plaintiff is doing here, ladies and gentlemen. Explain what the anchor bias is. Explain to the jury in voir dire that that's what the tactic is, and that's not their job. Or you can also use the opportunity to explain to the jury what a million is, like I said earlier. And so, attack it straight on by getting them to understand, pointing it out, and getting them to recognize that they should kind of reject this idea of an anchor bias. Another very, very important defense tactic, or I would say quiver in our bow, is motion practice. There are cases out there, and there are even some jurisdictions with legislation, which, there's always cases in most jurisdictions that talk about what is an excessive verdict. And a motion in limine or a pretrial motion to restrict the plaintiff from suggesting those numbers or from planting those ideas, whether successful or not, is a tactic that can be used. Objections just to let the jury hear you, to say, depends on the judge if they let you make a speaking objection, but get it in the jury's head that this is objectionable to you is another tactic that can be used in voir dire, in opening, and then of course, legislation. I mean, that's a longer term solution. I mean, this is a real problem that society does have to deal with, and that's another tactic. Any thoughts on those ideas?
Yeah, no, I think they're all fantastic ideas, Bob, and we should use them. But here in Florida, we're like the wild, wild west. We're the wild, wild south, and the plaintiff's lawyers get to pretty much do anything essentially. I mean, and plaintiff's lawyers they have to be creative. They have to, they come up with, they follow the rules for the most part, but they push them and they try to then, cross over and break those rules. And the judges allow them to do that sometimes. And so, but the defense lawyers and, our lawyers, we are strict rule followers. We just simply stay within the lane. And what we need to realize is that the plaintiffs are going to anchor, the plaintiffs are going to talk about numbers, and we can object, but we need to also do the same thing. And it's not against the rules, because if the judge is going to allow it, and it's not excluded in motion limited practice, it's not excluded on objection, it's not excluded, and we've pointed it out, it is not enough just to leave it alone. And hope that the jury will ignore the objection or ignore the ankle. We have to do it. And we as defense lawyers have to be creative and start thinking about how it is that we're going to anchor the number and what we're going to anchor that number to, and do it ourselves, right? So yes, fight it, with the objections and emotions in limine, but here in Florida, we know it's coming in. So we need to say, all right, this case has this value, and here's why I'm going to tell the jury why this case has this value. Even if it's a 100% defensible case, that's what we need to do.
100%. Two more things I want to discuss, and then we're going to open it up for discussion a little bit, okay? The one thing I want to really get to is anchoring in negotiation. So this is a tactic that is not only for trial purposes. Anchoring in negotiation is a question that's also I guess you'd say been disputed a little bit. Should the defense make the first offer? I can't even tell you how often I want to do it and clients don't want us to do it. Let's wait for a settlement demand. Let's wait for a settlement demand. And a settlement demand is itself an anchor. When it comes in high and they upset us and they're ridiculous and they're out of the ballpark, but now we're anchored to that number. And how do we respond to that? So how do you see anchoring as a tactic in negotiation?
I think it's a wonderful thing to do. The fact of the matter is that nowadays we're getting such ridiculous demands. I just got a demand in for $210 million. Listen, I don't know where
Okay, deal. Hey,
that
it's a deal.
that anchor is lost. It's at the bottom of the sea is where that anchor is.
Right.
But the fact is I've stopped negotiating, Bob, based upon what the plaintiffs are necessarily doing. I'm telling our clients now, if the case has that value, offer that money. I don't need to wait for the demand, right? And because I know what the value of the case is, they know what the value of the case is. We're not going to lose any ground by offering that money, because we would have settled for that anyway in these numbers that we're putting out, right? So offer up the money, let the plaintiff's lawyer know what field we're playing on. They won't play on your field either, but at least they're communicating that to their clients. Their clients are hearing these numbers, and that's exactly what I want to do. I want to always leave the plaintiff with that number that they could have actually taken before they didn't accept the offer in the case.
And as early as possible, once you have all the information, obviously, if you don't feel, and this is really in a way the crux of the question. So certainly oftentimes we're first noticed, or oftentimes all we really have is maybe a police report or an incident report, and then we talk to our insured and we find out what the story is, but we don't have a lot of information about the damages or the injuries or whatever. Sometimes it takes 3 months, sometimes it takes 6 months, so often it takes longer. You're always looking to get more information about the damages, There has to come a point where you have enough information to, obviously, for the insurance company to set a reserve. And so at that point, it makes some sense. And if you think about the psychology of what we've been talking about, of creating a expectation bias, knowing, as you said, that the plaintiff attorney is obligated to convey the offer, the response is always, you got to be out of your mind. These people are nuts. We're taking it all the way to the mat. We'll see you at court. That's ridiculous. I'm insulted. But guess what? You've created an anchor. Okay, you can always go up from that. You cannot go down. And so that's the way to create an anchor. And so I agree with you. Once you have enough information, once the insurance company feels as if it can set a reserve, it ought to be able to make an offer of some sort. And let's not be afraid of insulting anybody. It doesn't matter, because the psychology of it is that we've gained an advantage just by making the offer.
Right. I think that's a very good point. Very good.
Well, I want to open it up for discussion, but I want to show one more video, which I liked, which is all about be enthusiastic about your case. Okay. The enthusiasm of the lawyer makes a big difference. So let's watch this one, and then we'll open it for conversation.
The other thing is the defendant attorney, the woman, after he came up being kind of on the bravado side, she was like really soft.
Yeah, she seemed like she was sleeping or something.
That troubled me, especially after I thought I was on that side. I'm saying, come on, pick it up.
Yeah. Like she was bored, or she was being forced to talk or something. Yeah, I saw no energy level there. Or no passion. Like she had no passion or something.
He was passionate. Yeah. She was just giving facts.
Yeah. Very
it was like the plaintiff's attorney. He had slides. He had a good structure. He had it going on, and the hospital, I feel sorry for the people that they were representing, because honestly, they just did a poor job. They did not have slides. All they did was give us facts. But they didn't have, we're all used to these. Woo us in. Show us the facts in an interesting way that captures our thoughts and our emotions. They did a terrible job, and I am for the defendant. So I feel terrible. I wouldn't want them to defend me.
And that's funny. I know I broke a rule.
And there was 3 of them, and the one guy just blew them away.
I know.
Yeah, even if it was nonverbal, just from visual, you could tell who was passionate about it, who was prepared, and who wasn't.
It was almost like the woman thought it was a slam dunk, and she just was up here, and once we heard her talk, we just believe her. But because she didn't put, it just looked like there was no effort. Either she thought it was a slam dunk, like, oh, I'm gonna win this. I'm just gonna show up here and I'm gonna say this and you're gonna believe me.
Don't have her.
You know what I mean?
Don't have her stand behind the podium. Because all you could see was her head. It's just little stuff like that.
Sorry, I didn't mean to do
Just the other thing is
Well, we don't want to be talked about in that way, do we? Hopefully that's not a Hamilton Miller lawyer or a Kopka Pincus Dolan lawyer.
Never, never. I mean, this emphasizes the importance, even in mediation, of using visuals, right? And not PowerPoints that have a whole bunch of writing on the screen, but sometimes it's using actual evidence, call outs, pictures, diagrams. Those are the types of things that have an influence, not only on a jury, but also on a plaintiff who's watching the case, knowing that you're prepared to go to the mat, but you show up at mediation and you just, it's a lackluster presentation. Then there's no fear in the plaintiff's lawyer. There's no fear in the plaintiff for wanting to resolve that suit. They say, hey, if this is who I'm up against, then I'll roll the dice. I'll take my chances. So a good example, Bob.
Well, we didn't leave more than 5 minutes, unfortunately, for comments, but I think we covered a lot of things. Erica, if you want to open up the board, and if anybody wants to unmute themselves and make a comment, we'd be happy to listen to it and respond to any questions there may be. Just go ahead and unmute yourself and start talking. We hopefully won't talk over each other.
Have you ever had any success?
Oh,
Go ahead.
all right.
I was just going to say, have you ever had any success with anchoring in voir dire in federal court, since we're not allowed to actually voir dire the jurors?
Yeah, that's an interesting question. You can't do much in federal court at all. Actually, it's down here in the Southern District of Florida, they give us 10 minutes. And so, it's tough to anchor within that 10 minutes because we have so many other issues that we need to hit in voir dire in terms of, previous litigation history, prior accidents, any pain, any chronic pain that we need to cover it. I try, and federal judges federal judges won't shut me down here, at least in the Southern District. That's one of my questions that I want to burn in 10 minutes. But yeah, federal court's a whole different beast and animal, and I'm glad you brought that up. It's just very difficult to get that dialogue in, and it's difficult for the plaintiff to get that dialogue in also. So
I'll say this: you still have the opportunity to anchor an opening, and in closing, and throughout the trial, and it's something that I think defense attorneys have to think about. Brad, did you want to make a comment as well?
Well, I just want to have you ever had any success submitting proposed jury or voir dire questions to the federal court? And if so, what kind of language have you used?
Yeah, I haven't. I've not done it in federal court because, again, our federal court is so restrictive. I mean, we've got a couple of judges here that say, give us 5 questions that you want to ask. And then he'll give us, or he or she'll give us 10 minutes on top of that 5 questions. And so I really have not done it in federal court. In voir dire, but as Bob says, we do it in opening, we do it in through our experts, and then we do it in closing. It's just the voir dire is so limited.
Cecilia, you have a question?
Yeah. So just wondering, it seems like the way you kind of presented everything, that the best way to do this is for your anchoring to kind of be better than the other folks. To have all of the information, all of the details, so that your numbers make sense. But if you do find yourself in a situation where, they have done a better job at anchoring, or, maybe just the jury just grabbed onto their number for whatever reason, we all have our different biases. What tactics do you have to kind of pull back some anchoring that has already kind of gone to the other side, because you have the whole trial?
I mentioned a few. One is, when you hear it, you can identify it to the jury. This is what the tactic they're using. So don't be fooled by it. Okay, this is not your job. Okay, you can also, ultimately, you have to bring a number back to reality. So you can talk about the what $1 million is. You can even talk, as Jerry mentioned, about how we're being desensitized in our society about these numbers. Okay, just because they got injured doesn't mean that they can make what an NBA star or a football star makes. So you have to address those things directly. I mean, unfortunately we speak second, so we don't get the first bite at the apple, and we're not shooting for the pie in the sky. And we saw in the video that you can't lowball either. So it really your number has to be anchored to some rationality, and you have to appeal to the rationality, not the emotion, but the duty of the jury to compensate appropriately.
So just kind of keep going back at it, kind of throughout the whole, at every chance you get, even if, I get what you're saying.
Yeah, you talk about the plaintiff's numbers are never reasonable. I mean, they shoot for the sky. And, if you keep talking about that value of money and what that money then means to this particular plaintiff, then, you'll talk about the fact that you've given a rational and a reasonable approach to fair and reasonable damages, right? And that's what the law requires, is fair compensation, just compensation. And here's how we get to just compensation. And then we hammer on our number, and we hammer on the fact that here's what they testified to in terms of their loss and what it is that they're looking to replace. And here's how that money then replaces that loss, assuming that we're, again, in a full liability trial without any comparative fault and things of that nature. So just a damages trial that you can do, Cecilia, in terms of just coming back and anchoring again, showing how it is that you used your formula to come up with just, reasonable, and a rational approach to computing your damage, and why it is that your anchor is so much more reasonable and justified.
Other comments?
I had a comment as a longtime lawyer that always would anchor. I actually heard a 30-year lawyer tell me he won't anchor because it makes him look weak. And then I was fortunate enough to see him lose his case after making that comment. And this is how he lost it. And I think this is the reason why in every case you have to anchor. In this case was in Mississippi, and the rules there are similar to here in Florida and other jurisdictions, where the plaintiff gets rebuttal. And in that case, the plaintiff asked for $1,267.58. That was the lawyer that told me, no, I won't I gave him my alternate number. Observing the trial was 300. He says, I won't do it. It would make me look weak. He didn't do it. The co-defendant didn't do it. The plaintiff gets up on rebuttal, says, you never heard either lawyer say that $1,267.58 was unreasonable. That's all pretty much what he said in rebuttal. Guess what the verdict was? To the penny. And that's why you should do anchoring.
Good point, Carlos.
Well, thank you, Card. That was a good way to end, because we have used up the full hour. Jerry, once again, great to see you.
Yeah.
Fun to do. Thank you for joining us. Pleasure to meet all of your wonderful lawyers as well.
Yep, and same here, Bob. Thanks for setting this up. You're a shining and great example of, how a firm should be run and how we should share our knowledge. And I'm going to be stealing your idea and putting it in our firm now. So we're going to have quite a few more of these sessions.
I'm honored. Everybody have a good rest of your day. Thanks for attending. For those of us, I think if you need a copy of this, it is recorded, Jerry, so we can provide it to you. And it's always on our, for our firm, it's on our SharePoint.
Yep, I'm going to have it I'll put it on our intranet.
Goodbye, everybody. Bye, Jerry. See you soon.
Take care, Bob.
Thank
Bye-bye.
you.
Bye.
Bye-bye.